Your Excellencies, Ambassadors and High Commissioners, members of the Diplomatic Corps, senior officials of the Prime Minister's Office and other ministries, members of the Charles Telfair Campus Board, members of the Charles Telfair Centre Steering Committee and Editorial Committee, Professor Philippe Sands, GCSK and Queen's Counsel, Your Excellency Ambassador Jagdish Kunjul, GCSK and GOSK, members of the press, authors, colleagues, students who are online, members of the press, ladies and gentlemen, we are delighted to welcome you on our campus today for this lecture organized by the Prime Minister's Office in collaboration with the Charles Telfair Centre, the open source, non-partisan knowledge platform of the Charles Telfair campus. Thank you all very much for your presence today. We have present among us, here physically and online, decision makers from the public sector and the private sector, as well as from NGOs. We have researchers and students from various universities and international dignitaries. As a knowledge platform that aims to bring together an audience from diverse backgrounds around key issues pertinent to Mauritius and the region, it is an honor for us to host this lecture on the topic of the incomplete decolonization of Mauritius and its sovereignty over the Chagos Archipelago. It is through such diversity of opinion that we hope to advance ideas and encourage debate. My name is Myriam Blin. I am the head of the Charles Telfair Centre and I will be your Master of Ceremony this afternoon. Now, before we begin the event, I have a few housekeeping issues to go through. First of all, we would like to ask you to please keep your mobile phone on silent mode so as not to disrupt the event. And I'm checking my phone. I'm good. In case of a fire alarm, please choose the emergency exit that is the closest to you. We have an assembly point at the back of the building on top of the hill. For the restrooms, these can be found on my left and at the back of the room. We have hostesses around the room. Do not hesitate to ask if you need to do so. This event is being live streamed on Facebook. For those of you who are listening to us online, welcome. We invite you to use the emojis and comments section to share your thoughts and react to this event. Unfortunately, we are still in the midst of the COVID crisis, and we are therefore called to remain extremely vigilant. In order to protect us all, we have tried to facilitate physical distancing by displaying the chairs at a safe distance. You will also find hand sanitizers spread around the room and at the reception. Do not hesitate to use these. To keep everyone safe, I would like to encourage each of us to respect at all times the physical distancing between us and to please keep your mask on as much as possible. Thank you very much. When His Excellency Ambassador Kunjul and Professor Sands approached us via the Prime Minister's Office to ask us to host this lecture, as an independent think tank, we could have not been more delighted. The Charles Telfair Centre is a non-partisan, multidisciplinary platform of knowledge founded by the Charles Telfair campus. In just over a year of existence, through its online publication, its events, the Centre has successfully established itself as a reference for diverse, thought-provoking, and reliable knowledge on topics pertinent to Mauritius and the region. The geopolitics of the Indian Ocean lies at the heart of one of our key themes, sustainable management in the Indian Ocean. It is therefore entirely befitting that the Charles Telfair Centre hosts Professor Philippe Sands' lecture today. A lecture that will remind us that it has taken more than half a century for Mauritius to get an official recognition of its sovereignty over the Chagos Archipelago. More than 15 years for Mauritius to finally hope that an end of its colonization is in sight, and more importantly, that it has taken more than 15 years for thousands of Chagosians and their descendants who were forcibly removed from the archipelago to finally have a chance of returning to their native home. The plan for today is as follows. After this welcome note, we will have a short introduction by His Excellency Ambassador Kounjoul, Permanent Representative of the Republic of Mauritius to the United Nations. This will be followed by the main lecture delivered by our distinguished guest and internationally renowned barrister, Professor Philippe Sands, GCSK, Queen's Counsel, Professor of Law at University College London, and a barrister at Matrix Chambers. He is also the counsel for Mauritius and has appeared for Mauritius in international cases relating to the Chagos Archipelago. And today, the title of his lecture is A Short History of Colonialism, a Modern Crime Against Humanity, Chagos Archipelago, the last British colony in Africa. We will then devote 30 minutes for questions from the audience. To keep everyone safe and to avoid passing microphones between members of the audience, we would like to invite you to use the piece of paper that has been displayed on your chairs and to write your question and your name, if you wish to share your name, on the piece of paper. We will then pass on these questions to Professor Sands. Thank you very much. To introduce Professor Sands, I am delighted to welcome to the lectern His Excellency Ambassador Chagos Kounjoul. Ambassador Kounjoul has over 40 years of diplomatic experience across various geographies. As the current permanent representative of the Republic of Mauritius to the United Nations, Ambassador Kounjoul played a crucial role in securing, through his strong diplomatic skills, the votes of 116 countries at the UN General Assembly in support of the resolution reaffirming that the Chagos Archipelago forms an integral part of the territory of Mauritius, and setting a 6-month deadline for Britain to withdraw from the archipelago, in line with the International Court of Justice advisory opinion of February 2019. Over the years, Ambassador Kounjoul has worked very closely with Professor Philippe Sands on the Chagos issue, and as such, I am thrilled that he has accepted to formally introduce our distinguished guest this afternoon. Ambassador Kounjoul, the floor is all yours.
Thank you, Miriam. Honorable members of the Charles Telfair Campus Board, members of the Charles Telfair Centre Steering Committee and Editorial Committee, members of the Diplomatic Corps, and of course the Dean of the Diplomatic Corps, good afternoon and welcome to this lecture. Let me first of all thank Charles Telfair for hosting us this afternoon for this lecture. This is a wonderful place, as you can see, and I think everybody feels safe and comfortable being here with the physical distancing that has been arranged for you. We want to thank you for coming despite the scare linked to COVID-19, but let me assure you that you will all go out of here fully satisfied of learning what has been happening on the Chagos front for all these years. The Chagos issue is an issue of national interest. Everybody in Mauritius is more or less aware of the general story, but few may be aware of the details of how we have come to where we are today. And interestingly, on the Chagos issue, I can say that there are as many opinions as there are experts in Mauritius. And it is a good thing because it is a national issue and we should all have an interest in that. It is also very interesting that this is an issue that goes beyond party politics. There is a general consensus among all parties that this is an issue where Mauritius has to keep going until we are able to exercise our full sovereignty on the Chagos Archipelago. So today what you will hear from Philippe Centre is the different stages that we went through to be able to get to where we are. And I want to just maybe plug in one little part of it, and that would be the part where I came to know Professor Centre, and we started this exercise at the United Nations in 2016. As you are all aware, the whole issue of bringing the matter of the Chagos Archipelago to an international court or to an international tribunal started in 2010 when the UK decided to unilaterally establish a marine protected area around the Chagos Archipelago. Mauritius felt at the time that this was against law, against international law, and decided to take the UK to a tribunal. After the tribunal gave its verdict, basically stating that the establishment of the MPA was in violation of the United Nations Law of the Sea Convention, the government then decided that we should look at other avenues where we could pursue the matter further. And the most obvious place to go to at the time was the United Nations, because we could not bring a case against the UK at the International Court of Justice. Now, in 2016, we tried to put the item on the agenda of the United Nations. And we soon realized that at the UN, there were very few countries, very few ambassadors who knew what Chagos was all about. Many of them didn't even know where Mauritius was. And so there was a long period of education that we had to do to get people to understand the whole history of the Chagos Archipelago, the whole history of its detachment, and to justify why Mauritius was bringing a case to the United Nations. And for that reason, we felt that 2016 was not going to be the right year to bring this matter to the UN, and we felt that we should give ourselves time to educate the members of the United Nations. And when I made the suggestion that we should postpone the item until the following year, obviously we did not immediately find consensus. And that was when I first talked to Philippe Centre, not only as a lawyer for Mauritius, but as a friend, because he and our other external lawyer, Paul Reichler, were in Washington. And I called on him and I said, listen, we are going to have to defer the item for consideration the following year, because we need time to prepare ourselves, and you have to help me to secure government's approval to defer this matter until the following year. And it was thanks to that intervention that we were able to get the item on the agenda by consensus, so that there was no opposition at all for the item to be placed on the agenda. And that was our first victory, in the sense that this item found its way on the agenda of the United Nations without any opposition. I must say that had we not been able to do that at the time, we would have run into severe opposition from a number of countries, which basically said that we are opening the gateway for countries to bring this type of bilateral issues to the United Nations. So when 2017 came, the item was already on the agenda, and we had time to do this exercise of educating our colleagues at the UN with the help of our external team, external lawyers, and of course our excellent team that we have in Mauritius as well. We were able to sensitize the whole of the United Nations, and that is why when the resolution was put to the vote on June 22nd, 2017, we got a victory of 94 countries voting in favor, 16 only against, and 65 abstention, which meant that the issue was going to go to the International Court of Justice with two important questions, which I'm sure Philippe is going to develop. So, since then, the Mauritian government team, the diplomatic team, has been working in very, very close collaboration with the external team. And we consult on every single aspect of the matter practically on a weekly basis, not to say on a daily basis. And since then, we have been, I'm not going to say accumulating victory over victory, but certainly we have made tremendous advances on this matter. So with this, I want to just introduce Philippe Sands. I don't know where to start because he's such an accomplished person. Everybody knows him as an international lawyer, as an academic. He's a professor of law. He is a human rights defender, an activist in matters of environment, a promoter in matters of rule of law. And this reminds me that in 2003, 2004, when the Americans were going to war in Iraq, and they managed to convince the United Kingdom to join them in a kind of a coalition we didn't find any other partners or any other takers. Philippe wrote an important book and basically stated that UK government had taken the United Kingdom into a war which was completely against international law. It reminds me also that around the same time I was at the United Nations in the Security Council, and one of the important issues that we were looking at the time was whether or not the United States needed to have a resolution from the Security Council to go into war with Iraq. And obviously they never found that support, and then they decided to go on their own. So, to come back to Philippe, he is a writer of international repute. He has written more than, I think, 17 books in all, non-fiction books, and books that are so topical in nature. Many of his books have gotten awards. He has participated as a lawyer in several arbitral tribunals. He is probably one of the most renowned international lawyers, appearing at the ICJ in many cases, both advisory opinions and other bilateral litigations. He is a commentator on CNN, BBC, Al Jazeera, and several other, and contributors to several other newspapers. He is a winner of several prizes. Of course, has received many awards like the Henry Rollin Medal for contribution to international law, the Elizabeth Hobbs Prize for contribution to the environmental law, Prix du meilleur livre étranger for East and West, which is a famous writing that he has done. He is an honorary doctorate from the University of Leuven, and of course the Mauritius government has honored him with the title of Grand Commander of the Star and Key of Mauritius. He's also an actor and a playwright, something that I didn't know until 2017 when he invited me to one of the shows that he had in New York. So sometimes I, together with the other team members, we ask ourselves, where does he find the time to do all that? But clearly he does find the time, and in whatever he does it extremely well. So with these words, I would like to invite him to present to you the case on Chagos, and hopefully after that, as I say, you will be more aware of this issue and how and what Mauritius is doing or has been doing all these years in order to get to where we are. Thank you very much. Philippe, the floor is yours.
Thank you very much, Ambassador Kunjul. Thank you, Madame Blin. Thank you to the Charles Telfair Centre. Thank you to the Prime Minister's Office for the invitation. It's a real honour to be here, and it's terrific to be back in Mauritius after these difficult and continuing difficult times. This lecture is about a place called Chagos, an archipelago that is scattered across a vast swathe of the Indian Ocean. I'm not a neutral observer. For a decade, I've acted as counsel for Mauritius in a place the United Kingdom government calls the British Indian Ocean Territory. The government website from London describes an archipelago of 58 islands covering 640,000 square kilometres, a British Ocean Territory administered from London, located approximately halfway between East Africa and Indonesia. Access to the area is restricted, the site tells you, although wealthy owners of yachts are free to apply for mooring permits. The website doesn't tell you anything about Chagos's past, or that it is Britain's last colony in Africa, or that Britain is an illegal occupier of the islands, or that its former residents, some of whom are here today, were forcibly deported from their homes and wish to return. Britain hangs on to Chagos. It issues colourful, beautiful stamps like this one issued this year, the Royal Angelfish, adorned with an image of Her Majesty the Queen. The Biot Post Office or the Stanley Gibbons shop will not tell you that these stamps cannot actually be used anymore. But more about this in a moment. Let us begin with a first-hand account, a very short video that was first shown in September 2018 in the Great Hall of Justice in The Hague. It's a witness statement made for the judges of the International Court of Justice. Madame Elisby Elise, who I honour and who is here today with us, offered to the judges a first-hand account of what it means to be removed from your home on Peros Banhos in 1973 and her continuing desire to return.
Je m'appelle Lisby Élysée. Je suis née le 24 juillet 1953 dans Peros Banhos. Mon papa né dans ces îles, mon maman né dans Peros Banhos. Ma grande famille aussi est née là-bas. Je fais partie de la délégation mauricienne. Je peux raconter toutes mes souffrances depuis que je me déraciné le Mosile Paradis. Je suis content que la Cour internationale peut accueillir nous aujourd'hui. Et nous sommes confiants que nous pourrons retourner dans Mosile, que tout le monde prend naissance. Dans Chagos, tout le monde est dans ce travail, est dans sa famille, est dans sa culture. Mais nous tu manges tout ce qui est frais. Bateau qui tu sorti depuis Maurice, tu amènes tout nous bonnes marchandises. Nous tu gagnes nos rations, nous tu gagnes tout ce qui nous nécessaire. Nous pas tu manques rien. Dans Chagos, tout le monde qui vit une bonne la vie. Mais un jour, l'administrateur qui finit dire nous, qui nous pour bizarre quitte nos îles, quitte tout nous la case, nous aller. Tout le monde pas un peu content, je suis en colère, qui fait il dit nous bizarre aller. Mais nous pas à soi, pas nous laisse nous connaître qui fait. Jusqu'à aujourd'hui nous pas connaître qui fait nous peut bizarre aller. Mais après bateau qui tu peux amener manger, fin arrête venir. Non rien nous pas là pour manger. Aucune médecine, aucun rien. Nous passe bien misère. Mais après un bateau qui vient, appelle notre verre. L'administrateur qui nous dit à nous, qui nous bisait embarquer, qui tous nos bagages, qui tout ça qui nous est là, pour 10 nous laisse nous aller. Et ça, ben du monde qui bien en colère qui fait ça. Et quand fait ça dans le noir. Nous embarquer dans le noir pour nous pas trouver nos îles. Et quand nous finissons embarquer dans ce bateau là, avec mauvaises conditions. Nous avons un ban d'animaux, un ban d'esclaves de ce bateau-là. Ban du monde qui type mort à la sagrin de ce bateau-là. Et moi, à l'époque-là, je suis enceinte 4 mois. Le bateau-là prend 4 jours pour y arriver Maurice. Mais quand il est arrivé, moi, mes enfants finaient et ils finissent morts. Je dis à qui fait mes enfants finissent morts parce qu'ils m'ont traumatisé de ce bateau-là. Je j'ai beaucoup de tracas, je suis bouleversé. À cause de ça, même qui mes enfants finaient, ils morts. Moi, je dis, nous ne devons pas perdre l'espoir. Nous devons imaginer qu'un jour, nous pourrons tourner dans la terre que nous sommes. Molécule a peu souffert et molécule a encore attaché avec nos îles que nous sommes. Les personnes qui ne sont pas contentes, qui sont dans l'île que nous sommes, pour déraciner comme un ban d'animaux. Et ça fait l'équerre faire mal. Et moi, je dis, la justice bizarre faire. Et mon bizarre retourne dans mes îles. Que de mener. Est-ce qu'il ou quoi, pas faire l'équerre faire mal, quand on dit me déraciner les îles, comme un animal, pas connaître que de perdre nous, et mon bien sacré jusqu'à aujourd'hui, je pas connaître même comment on sorti dans mon Chagos. Il fait nous sortir par force, et mon bien sacré, et mon langue collée tous les jours, mon mazine, qui me bizarre retourne dans mon île. Me dit à mon bizarre retourne dans mon île que de mener, et mon bizarre almo là-bas, et que nos grands-parents finissent enterrés dans l'endroit que nous prenons naissance et dans nos îles natales. Je m'appelle.
I came to know Lisby Elysée a few years ago, and I'm so happy that we have stayed in touch. When she first told me her story, it resonated. It reminded me of other deportations, of my 2 great-grandmothers who were deported from Vienna in 1942 to a place called Theresienstadt. I wrote about it in my book, East-West Street. Like them, Madame Elysée was allowed to take just 1 suitcase. When we were at the court 3 years ago, she asked me why it had taken so long to get to The Hague. Justice is a long game was the best I could come up with. The roots of her journey started before her birth, in August 1941, when Franklin Delano Roosevelt and Winston Churchill signed the Atlantic Charter, setting out their hopes for a better world. Churchill didn't realize he'd walked into a trap laid by Roosevelt. Paragraph 3 of the Charter committed the 2 countries to respect the rights of all peoples to choose the form of government under which they will live. For Roosevelt, the Charter was intended to end the British Empire, to offer the colonized a promise of their own nation-state. Churchill read the document very differently. He told the House of Commons that the 3rd paragraph was for those under the Nazi yoke, not for British colonies. But the reading wasn't widely shared, particularly in Africa. For example, a young Nelson Mandela, who read the words as heralding new rights, full citizenship, and an end to discriminatory legislation. One thing led to another. The Atlantic Charter was followed by the UN Charter, Article 1 of which committed all members to respect the principle of self-determination. The language was new and revolutionary. It unleashed a process of decolonization. By the 1960s, however, still large parts of Africa remained under colonial rule, as France, Spain, Portugal, Belgium, and Britain too hung on to their distant possessions. In Mauritius, here, the British governor, Sir Hilary Rudolph Robert Blood, remained happily ensconced, as he wrote, in my pocket handkerchief paradise. In 1960 in Cape Town, Harold Macmillan evoked a wind of change blowing through the continent of Africa. 16 African countries joined the UN that year. A British diplomat in New York complained bitterly that decolonization was basically based on emotion, not reason. It was, he wrote, a form of colour prejudice in reverse. It reflected, he wrote in a report to London, an unjustified resentment of the darker peoples against the past domination of the world by European nations. As he wrote, self-determination reached the floor of the General Assembly under the presidency of Frederick Boland, an Irish diplomat. His daughter, Eve Boland, would become a famous poet, and I commend to you her poem, What is a Colony? On the afternoon of 14th of December 1960, 89 countries voted in favour of this resolution, 1514. None voted against. 9 countries did abstain, and Britain was one of them. Resolution 1514 declared that all peoples have the right to self-determination. It proclaimed a principle of territorial integrity and prohibited the partial or total disruption of the national territorial integrity of a colonized country. Britain explained its abstention. We're in favour of a principle of self-determination, it said, but not of a legal right. Mr. Boland, on the other hand, was delighted, and he ended the Assembly session on an upbeat note. The Assembly may well congratulate itself on this important accomplishment. The right of self-determination came into being as the people of Mauritius urged Britain to give them independence. At the same time, the US was developing a new policy of placing military bases on distant atolls. Mauritius became a colony of Britain in 1814 by the Treaty of Paris, ended the Napoleonic Wars, prohibited trade in enslaved people, and ceded various colonies of France to Britain, and one of those was Île-de-France, known to the British as Mauritius. It came with dependencies, including the Chagos Archipelago, about 2,000 kilometers away, actually close to the Maldives, a British protectorate. Chagos was, as I've mentioned, 58 islands and atolls. They included Diego Garcia, and hundreds of kilometers to the north, Peros Banhos, named after Pero de Banhos, a Portuguese explorer who perished there in 1555 when his ship, the Conceição, ran aground. The mariner Manuel Rangel recorded the event and the travails of the 165 travelers, including 2 women and 5 Catholic priests, who found themselves stranded on a tiny island and were extremely surprised to be met by a group of black people with their boats. The 1814 treaty ceded all of Chagos to Britain, with its copra and oil-producing plantations worked by enslaved people introduced from a place called Mozambique. By the early 1960s, as self-determination was written into international law, Chagos had about 2,000 inhabitants, most of whom worked for the Société Huilière de Diego y Peros, and they were descendants of the original enslaved inhabitants. Britain resisted independence, but secretly it acceded to an American request to make one of the islands, Diego Garcia, available on a long-term lease. It would be a communications facility. The British decided to empty all of Chagos, to remove the inhabitants at HMG's expense. We can do this, a Whitehall memorandum concluded, but we must avoid the charge that we're trafficking in colonial territory or disregarding the interests of the inhabitants or creating a new colony. They knew exactly the illegality they were perpetrating. Ever inventive, civil servants and lawyers in London sought to circumvent international law. The Americans asked the British to detach all of Chagos from Mauritius, although they would only use Diego Garcia. London agreed. It had declined to participate in the war in Vietnam, so Harold Wilson felt he had to give the Americans something. It must be done as rapidly as possible, Wilson concluded, and in utmost secrecy to avoid scrutiny. The Mauritians objected. Invited to London to discuss independence, on September the 23rd, 1965, Wilson met the Mauritian leader, Mr. Ramgoolam, at 10 Downing Street. He had a briefing paper that told him how to deal with the Mauritians. And I quote, you can see it here. The object is to frighten him with hope. Hope that he might get independence. Fright lest he might not unless he's sensible about the detachment of Chagos. You can return home with independence or without it, Wilson told Ramgoolam. Diego Garcia can be detached by order in council or with your agreement. Ramgoolam proposed a lease. Wilson refused. In those circumstances, an understanding was reached. Mauritius would get its independence with a little compensation and a few trade and other concessions. The British would undertake that if the facilities' need disappeared, the island could be returned to Mauritius. Under intense pressure, and very reluctantly, a majority of the Mauritian ministers in London agreed to detachment under these pressurized conditions. On September the 24th, 1965, Britain announced independence from Mauritius. Behind the scenes, Colonial Secretary Anthony Greenwood prepared the way forward. Present the UN with a fait accompli, bypass Parliament, adopt an order in council, detach Chagos, create a separate colony, and do it right now. There remained, however, one very human problem. What on earth to do with the inhabitants? The British and Americans agreed to proceed on the basis of an outright lie. They would tell the UN that Chagos had virtually no permanent inhabitants. Not good enough, said Lord Caradon, Britain's permanent representative to the UN. Get rid of the word virtually, as any population will cause Britain to be accused of violating its charter obligations to the permanent inhabitants. So the word virtually was removed, and Britain told the UN that Chagos had no permanent population. The Chagosians were just contract labourers. We must be very tough, a Foreign Office official recorded. The object is to get some rocks which will remain ours, so Chagos becomes a place with no indigenous population except seagulls. The fiction, and I'm quoting from British texts, opened up Britain's fertile colonial imagination. Along with the birds go some few Tarzans or men Fridays whose origins are obscure, the official wrote. The Privy Council in London duly made its order, created the new British Indian Ocean Territory, the whole of Chagos. It changed the constitution of Mauritius by removing Chagos from the territory, and it gave the new Biot Commissioner the power to remove the entire population. News reached New York, prompting an instant reaction. The General Assembly passed a resolution, deeply concerned and instructing Britain not to violate the territorial integrity of Mauritius. Britain just chose to ignore the resolution. 2 more resolutions followed over the next 2 years, both ignored. Instead, Britain entered into an agreement with the US, declaring Biot to be British and available for the defence needs of both countries for 50 years until 2016, to be extendable for another 20 years until 2036. And there would be no charge to the Americans, a most British gift. In March 1968, Mauritius duly became independent, and a month later, it joined the United Nations. The Americans occupied Diego Garcia. The famous comedian Bob Hope visited on that first Christmas, accompanied by a troupe of 75 performers, including 32 American beauties, as he called them, and Miss Australia, who had recently been crowned as Miss World.
We started out early Christmas morning to pay a visit to 1,200 sea bees stuck in the middle of the Indian Ocean on a fly speck called Diego Garcia. This 2,200-mile detour was a command performance, our answer to a lot of requests of the sea bees and their relatives. Finding it was only a minor triumph. We were the first jet to attempt to land there. The sea bees had worked feverishly the last 2 weeks to make this possible. Then we were greeted by a torrential tropical wind and rain. These sea bees were determined to have a show. They waded through the downpour. Nobody budged. Finally, after an hour or so, it cleared enough. And, well, I better get out there and get to work before they mildew over. Where are we? Diego Garcia, huh? That's a little embarrassing because we started out for Honolulu. But we're awfully glad they slid the island under us when we dropped in, I want to tell you that. I'd like to thank you for inviting us here and the Flies for giving us permission to land. Our Seabees here share this base with the English. They coexist beautifully in spite of the language barrier.
The old movie makes clear the deportations had already begun. Starting in Diego Garcia between 68 and 73, the entire population of Chagos was removed. 2,000 human beings deported to Mauritius and the Seychelles, and years later, many would go to Britain, to Crawley near Gatwick Airport. And incidentally, the British government today is trying to deport a lot of those back to Mauritius. In the years following independence, Mauritius had other concerns making its way in the world. Then in 1982, at the UN General Annual Meeting, Prime Minister Anirudh Jugnauth called for the return of Chagos, illegally detached. And the Chagossians too began to agitate, litigating before the English courts with some success. In 1998, Olivier Bancoult, Madame Élysée's nephew, won an important ruling from the High Court declaring the deportations to be illegal. And then Foreign Secretary Robin Cook agreed that they should be able to return to the outer islands. Then 9/11 happened. The US base at Diego Garcia was used as part of the Bush administration's program of extraordinary rendition, aka torture, and in March 2003 to launch the war on Iraq. A year later, in 2004, the British government reversed its decision to allow the Chagossians, Madame Élysée and all the others, to return to their homes. This caused protests in Port Louis, as you can see, the British High Commissioner being greeted by Chagossians, including their children, carrying placards and claims. The crime against humanity claim is not new. And this was how matters remained until the spring of 2010, when David Miliband, the British Foreign Secretary, announced that Britain would create a marine protected area around Chagos, over 250,000 square miles. The MPA would protect oceans and biodiversity and burnish Britain's green credentials in the run-up to a general election. And it would cast a more favourable light on Chagos than its use in Iraq and on the war on terror. Moreover, it would ban fishing and all other human activity. The UK takes its international environmental responsibilities seriously, Mr. Miliband declared. Conservation groups were thrilled. The Zoological Society of London hailed the proposal, along with Pew, a big US group, and later the Chagos Conservation Trust and the Bertarelli Foundation. A historic victory for global ocean conservation, they declared, but they were totally silent about the Chagossians, who were understandably deeply disturbed about the announcement of which the use to which their homeland was to be put. The government of Mauritius was equally concerned. Just a few months earlier, at the Commonwealth Heads of Government meeting, Gordon Brown had assured Prime Minister Navi Ramgoolam that Britain would not act unilaterally. As Port Louis pondered its options, WikiLeaks unloaded millions of pages of US top-secret papers, some of which related to Chagos. Of particular note, and I read it with care, was a 2009 cable from the US Embassy in London to Washington on the MPA. The document recorded the views of Mr. Colin Roberts, Director of Overseas Territories at the Foreign Office, extolling the virtues of Mr. Miliband's plan, one that would prohibit all human activity, except, of course, on and around the US base at Diego Garcia. And the proposal would create no difficulties at all for the local population, Mr. Roberts said, because there is no population, there are no inhabitants. We do not regret the removal of the population, the cable reported him as saying. So there would be no human footprints, no Man Fridays on Biot's uninhabited islands. This is language from 2009. The marine park would forever put paid to resettlement claims of the archipelago's former residents, Mr. Roberts explained. Marvellous, appalling. Environmental protection is being harnessed to stop the Chagossians from returning forever. This was a document of the kind that stiffens the backbone. the Chagossians lodged a new case at the High Court, Banku number 4, challenging the MPA on the grounds that its true purpose was to prevent the return of the Chagossians. The case would be rejected, like others, by the Supreme Court in London, but not before it threw up a vast raft of government documents that shone a bright light on Britain's actions between 1969 and 1973 behind the scenes. By now, KPMG, the accountancy group, was reporting that a return by the Chagossians was feasible. It could happen, there would be artisanal fishing, small coconut plots, and ecotourism could provide jobs, and it would have no adverse environmental effects. But the British government decided against resettlement for reasons of feasibility, defence, and security, and cost. The Chagossians mounted another legal challenge, Banku number 5, and leave for appeal on that case is today pending before the Supreme Court. But Mr. Maliban's announcement did something else. It prompted Prime Minister Navi Ramgoolam's government to reach out to the lawyers, and I want to pay tribute to that government decision and to one of the advisors who's here, Mr. Milan Mitaban, with whom I had the pleasure of working very closely in those early days. I became part of a legal team that was tasked with challenging Britain's actions under international law, working with Paul Reichler and the late and very sadly lamented my dear friend James Crawford. Options were limited because the Foreign Office had closed off the possibility of Mauritius suing directly at the International Court. So the path chosen was the UN Convention on the Law of the Sea and arbitration proceedings to get a ruling that the MPA was illegal because Mauritius had not been consulted and because Mauritius was the coastal state, not the UK. 3 years of pleadings, a remarkable hearing in Istanbul at the Pera Palace Hotel where Agatha Christie wrote Murder on the Orient Express, and then an arbitral award. It was by now spring of 2015. The 5 arbitrators ruled unanimously that the MPA was indeed illegal. Britain had violated its obligations to Mauritius under the law of the sea on fishing, marine resources and seabed minerals, and had failed to engage in proper consultations. On the other hand, by a narrow majority of 3 votes to 2, the tribunal decided it didn't have jurisdiction to decide which country was the coastal state. The majority concluded that the tribunal could not express a view on sovereignty over land, the islands, or the effect of Resolution 1514 and the principle of territorial integrity. However, and very significantly, 2 arbitrators disagreed. The arbitral tribunal could, in their view, decide who was the coastal state, and they determined that Mauritius was the coastal state. In 1965, they wrote, Mauritius had not consented to the detachment. Harold Wilson's frighten them with hope argument was duress, and so the whole enterprise, in their view, was illegal and without effect. The 2 dissenters, and I salute them, Judge Kateka of Tanzania and Judge Wolfram of Germany, had opened a new door. Their dissent and the fact that the other 3 arbitrators said nothing in support of Britain's claim caused Mauritius to ask again the question, is there a route to The Hague? By now there was a new government in Mauritius led by Sanarud Jugnauth. He wanted us to be able to go to the International Court of Justice, and we explained that there was a route. The International Court of Justice can give advisory opinions to the UN General Assembly. Back in 2010, we'd also discussed that possibility, but advised against the option because we were concerned about the prospect of persuading a majority of the UN members to vote against the US and the UK, who are permanent members of the Security Council. But circumstances had now changed. 2 arbitrators had found in favour of Mauritius's claim, and none had found against it. And then Britain voted to leave the European Union. As some British ministers waxed lyrically about creating a new Empire 2.0 and alliances with Commonwealth countries around the world to reconquer the world, the reality was brutally different. Britain's international authority suffered an instant collapse. This was apparent in the UN General Assembly's General Committee, a body of 26 members, and I pay tribute to Ambassador Kunjul, who led the effort here to place the Chagos issue on the General Assembly's agenda. Without EU votes or lobbying, Britain had no majority. And so it was agreed that if Britain and Mauritius couldn't resolve their differences by June 2017, the ICJ advisory opinion matter would be voted on by the General Assembly. There were talks over that year, but as always, no progress. In June 2017, the General Assembly did debate Chagos and decided to vote on a request for an ICJ advisory opinion. A draft resolution circulated on behalf of the 54 members of the group of African states supported by non-aligned movements. Just out of your interest, the first ever draft of that resolution was prepared in a Starbucks near the White House, written out by me, James, and Paul Reichler on the back of a Starbucks napkin. It was supported by the African states and by the non-aligned movement. Britain opposed, supported by the US, whose ambassador, Nikki Haley, warned that it would be inappropriate to seek an advisory opinion on a bilateral dispute, and it would set a most dangerous precedent. I travelled to New York to lobby with the Mauritian team, led by Sir Anirudh and in the presence of a delegation of Chagosians. Britain warned that the UN was being used as a backdoor route to the court and would compromise the institution. I spent hours seated at a small table in the Indonesia lounge, meeting delegates from dozens of countries, mostly legal advisors, and actually quite a few of my former students. Over a full day, only 2 delegates, a genial Australian and a rather sensitive Canadian, expressed any inclination to support Britain, although they did that with little enthusiasm. Most delegates were from Africa, Asia, and the Caribbean. None were hostile to Britain as a country. All described British pressure to vote against the resolution or abstain, but not one suggested they'd succumb. Many of those delegates evoked Britain's continuing colonial and, frankly, racist instinct, patronising, entitled, hubristic. And I learned a great deal that day. I learned about the gap between how Britain sees itself in the world and how most others in the world now see Britain. The decline in authority, eyebrows raised at the mention of the British Foreign Secretary's name, his articles replete with their racist epithets and racially charged put-down of President Barack Obama, very well known in the halls of the General Assembly and going down a lot less well there than with the readers of the Daily Telegraph. And then the vote, one of the most remarkable moments in my professional life. The General Assembly's membership board lit up, green in favour, red against, yellow for abstention, black for absence. Resolution 71292 passed with a big majority, as Ambassador Kunjul mentioned, including many abstentions that were significant, China, Russia and France. Only Croatia and Hungary of the EU supported Britain, along with only 3 of the 54 members of the Commonwealth. And, significantly, not a single country from Africa, Latin America or Caribbean voted with Britain. Global Britain? I think not. More Little Britain. The General Assembly sent 2 questions to the court. The first asked whether decolonisation had been lawfully completed, given the detachment of Chagos. The second addressed the consequences if the court ruled detachment to be illegal. The case now had a name, legal consequences on the separation of the Chagos Archipelago from Mauritius in 1965, and a timetable, 2 stages of written pleadings, and then a hearing. By the time the case was heard in September 2018, Britain had lost its judge on the court, defeated in a closely fought election by the candidate from India, a consequence of the toxic combination of Iraq, Chagos, and Brexit. It would be the first time in history that Britain would not have a judge on the International Court. The first to address the court at the hearing was Sir Anirudh, the last survivor of the Lancaster House Conference in 1965. And on that first morning, the judges watched Madame Élysée's video, and they watched Madame Élysée, who sat in the court in the front row. Britain followed, led by the Solicitor General. Normally it would have been the then Attorney General, but he was conflicted, having previously offered advice that fully supported Mauritius's position. Incidentally, that gentleman is today on the front page of every British newspaper. Ms. Buckland, the Solicitor General, set out the British government's arguments. The court should not exercise its jurisdiction, and in any event the detachment was perfectly lawful. What about the Chagosians? Yes, the British said, the manner of their removal was shameful and wrong, but he passed in silence on the fact that it had ever occurred. Madame Élysée's words were very moving, the Solicitor General said, and he expressed deep respect to the Chagosians, but not enough respect to right the wrong, not enough respect to offer a concession on a return, not enough respect to say that anything more than a little bit of compensation was sufficient. 23 countries participated in the hearings. The UK and US were supported by Australia and Israel. Pretty much the rest of the world, every continent, supported Mauritius. South Africa, and I pay tribute through its ambassador here today, spoke with a special authority, as 5 decades earlier it had adopted the positions now being articulated by Britain in respect of its illegal occupation of Namibia. As a former colony counsel for South Africa said, "We know all about colonialism and deportations and their continuing effects, and what it means when entire communities are taken from their homes on the basis of race. There is no such thing as part freedom," Council for South Africa concluded, "and decolonization can never be partial." It was an immensely powerful speech, and the last line, of course, came from Nelson Mandela, whose bust happened to stand on a pedestal right outside the Great Hall of Justice. The court gave its decision in February 2019. It had jurisdiction. There were no reasons not to exercise it. It would give an opinion. On the merits, the facts were clear. The British and Americans had discussed. They'd reached an agreement. Chagos was detached. Independence followed. The Chagosians were forcibly removed. So was decolonization completed? No, it was not. Resolution 1514 reflected the law already in 1965, and international law prohibited the disruption of the territorial integrity of a country without its consent. Did Mauritius consent? No, it did not. The court ruled that the detachment of Chagos was not based on the free and genuine expression of the will of the people concerned. The detachment was unlawful. It created a new colony. The decolonization of Mauritius therefore remained incomplete. What are the consequences? The court asked. Britain's occupation of Chagos is illegal and is a continuing international wrongful act. Britain must end its administration as rapidly as possible. Chagos is part of Mauritius, the court concluded. It then passed the baton to the General Assembly, including the future of the Chagosians. Only one judge dissented, the American, but she did so not on the merits, but only on jurisdiction. She believed the court should not have exercised its jurisdiction. If you read her opinion, you will see she offers no support to the United Kingdom for its claim. If you had asked me, actually, in advance, would we get a unanimous decision from the International Court of Justice, I would have said extremely unlikely. That really was an extraordinary moment. 3 months later, and it was an extraordinary moment that upholds the views of those who, back in 2010, argued that we should eventually end up in the General Assembly of the United Nations, and I want to record that. 3 months later, in May 2019, the General Assembly debated the implementation and a draft resolution, 73295. Prime Minister Pravin Jugnauth now spoke for Mauritius, ably supported, I have to say, by Ambassador Kunjul. The draft welcomed the court's opinion, affirmed that Chagos is an integral part of Mauritius, and ordered Britain to withdraw its colonial administration by November 2019. The Chagosians were entitled to resettle as a matter of urgency. The UN, its members, the specialized agencies, and all other international organizations were required to recognize Chagos as part of Mauritius. They must also ignore all measures purportedly taken on behalf of the British Indian Ocean Territory. And as you can see from the screen, the resolution got an even bigger majority. Support had grown to 116 countries, and those voting against fell from 16 to just 4 in support of London and Washington. Israel, the Maldives, Australia, and Hungary. Embarrassing, the New York Times would report. The British ambassador offered a last word. Depleted, crumpled, eyes watery, she dissembled. Britain is firmly committed to self-determination, she declared in a surprising response to Argentina's reference to the Falkland Islands. But she wanted to make clear there would be no dialogue on sovereignty until the Falkland Islanders wished for it. It was hard not to feel some sympathy for a distinguished diplomat placed in so awkward and, frankly, humiliating a situation. But one rule for the white Falklanders, another for the black Chagossians, was what many heard her to be saying on behalf of her country. It was a most unfortunate moment. So what came next? The advisory opinion and the General Assembly resolution arrived in the dying days of the administration of Theresa May and landed in the inbox of Foreign Secretary Jeremy Hunt. His advisers offered two options. The realists proposed that Britain, the US and Mauritius sit down and sort the matter out together on the basis of the definitive legal ruling. The government may not like the advisory opinion, but it was what it was, and Britain would have to live with it. Moreover, this line of advice said, Mauritius has publicly committed to the continuation of the US base at Diego Garcia. But that view was opposed by the fundamentalists, pushed by the National Security Advisor, who believed Chagos was so indispensable to British national security that it should simply ignore the ruling, hunker down, and just carry on as though nothing had happened. Regrettably, it is the latter view that prevailed. The British government simply declared the court had got it wrong and that it, London, had no doubt about its sovereignty. The court should not have exercised jurisdiction. It had erred on the facts and the law. And in any event, the advisory opinion was not binding as such on the UK. Exactly the same arguments as made by South Africa in 1971. Moreover, the British said no return for the Chagossians. The US offered support, but Mr. Trump declined Mauritius's offer of a long-term lease. Messrs. Johnson and Raab have continued that policy, which remains the policy of the British government today. The Labour Party, for its part, has made clear that it would maintain Britain's traditional position of respecting the rule of law and would honour the ICJ decision and recognise the right of the Chagossians to return. The decision by the May government and implemented now by the Johnson government makes Britain an illegal occupier of a part of the territory of Mauritius. It is as simple as that. There is no difference from South Africa's illegal occupation of Namibia after 1971. So, is it the end of the matter? It is not. The advisory opinion has legal effects for the UN, and the UN has changed its map of the world, as you can see here. This is the new map showing Chagos as an indisputable part of the territory of Mauritius. Legal advisors of the UN and its specialised agencies have met and committed to give full effect to the ICJ advisory opinion and the UNGA resolution. For example, the Food and Agriculture Organization in Rome has declined to recognise Britain's claim to be the Chagos coastal state for fisheries purposes. The Universal Postal Union has recognised Chagos as part of Mauritius and decided it will not register, distribute or forward any postage stamp issued by the territory of the formerly known as the British Indian Ocean Territory. It will remove all references to Biot. And it means that those lovely Biot stamps that I showed you at the beginning will now have no international validity. How troubling that they bear a portrait of Her Majesty the Queen. The other specialised agencies will in due course surely follow suit. We can expect the ITU, for example, to be invited to resolve that UK authorised telecommunications services operating on Chagos are unlawful, or the ICAO to decide that the UK has no right to regulate flights in and out of Chagos, and so on. Step by step, Britain will have to confront the legal reality. And courts too will follow suit. Indeed, some already have. In February 2021, the International Tribunal for the Law of the Sea ruled that the advisory opinion had determinative legal effects, so that Mauritius was to be recognised as the coastal state for the delimitation of the maritime boundary that divided Chagos and the Maldives. When the Maldives declined to accede to an invitation from Mauritius to negotiate a maritime boundary, Mauritius sued in Hamburg. The tribunal quickly rejected the Maldives' argument that the tribunal had no jurisdiction. The Maldives argued, but the islands are claimed by Britain. No, 9 judges ruled. There is no longer a dispute over sovereignty. Following the ruling by the ICJ, the matter has been definitively resolved. Britain's claim is contrary to the determinations of the ICJ, and the tribunal will now proceed to delimit the maritime boundary. What is Britain's reaction? Well, once again, it's just chosen to bury its head in the sand and hope that the whole wretched problem will no doubt about its sovereignty, blah, 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 and the ICLOS judgment would have no effect for the UK or for the maritime delimitation between the UK in respect of Biot and the Maldives. It was crazy. Is London now going to negotiate its own maritime boundary with the Maldives in parallel to the one delimited by ICLOS? That is what he seemed to be saying. Curiouser and curiouser. It's Britain in Wonderland. But the British government is not alone. Private businesses have turned a blind eye to the legal realities. Sure, a Bahrain-owned telecoms company continues to offer telecom, broadband, telephone services to those living on Biot and nearby mariners, according to its website. These services are all internationally illegal because they have no license authorized by the Mauritian authorities. And followers of sporting activity may be familiar with advertisements and hoardings for sportsbet.io. You'll have seen them if you watch the Premier League, as I do. Sportsbet.io is a betting company, but you probably don't know that the .io domain name stands for Indian Ocean, and that is nominally assigned to the British Indian Ocean Territory, a domain that is highly popular with tech companies and is far more expensive than others. Its use by this and many other companies is allowing someone somewhere out there to make vast sums of money out of an illegal expropriation of the territory of Mauritius. The Pobjoy Mint in Surrey continues to issue and sell Biot coins. Indeed, just a few months ago it issued a 50-pence coin bearing a portrait of Her Majesty the Queen on one side and the Chagos anemone on the other side. It is better known as the clownfish. The Zoological Society of London, this is the website, accessed today. Patron Her Majesty the Queen promotes its marine conservation work in Chagos as one of the most amazing marine environments anywhere in the world. It continues to issue reports and to plan scientific expeditions on the basis of the wholly unlawful assertion proclaimed in the website that Chagos is part of Britain. It cites its continuing work with Bertarelli Foundation as a global example of science and conservation activity and heralds a team of 50 researchers from 14 institutions across the world without offering even a hint of the illegality of the entire exercise. The chief executive of the Zoological Society of London happens to be a former British FCO diplomat. Let me be clear. Personally, such conservation work is hugely important, and I would fully support it if it was done lawfully. That's to say, authorized by the authorities of the only country in the world recognized in international law to have sovereignty over that area. And that country is, of course, here. It's Mauritius. All the Zoological Society needs to do is ask for permission. All the scientists need to do is ask for permission. All the foundations that are thinking of grants need to do is ensure that the work is duly authorized by Mauritius. Another British company, MRAG, offers scientific advice and support to the British government on the management of the illegal Chagos Marine Protected Area, including the solitary boat that is said to patrol 250,000 square miles. This was the boat in the course of the MPA arbitration in Istanbul that we learned was the principal source of pollution in the Chagos Archipelago. You literally couldn't invent it. The main source of pollution in Chagos is the boat that is intended to prevent pollution. These and other activities are premised on Britain's absence of doubt as to its sovereignty. This despite the fact that as of today, 28 international judges and arbitrators have addressed the Chagos issue, and not a single one, has expressed any support for Britain's claim. 24 judges have ruled that Mauritius is sovereign, and the other 4 have expressed no view on the matter purely on jurisdictional grounds. Having made its argument, Britain has not been able to persuade a single international judge to support the merits of its claim. The US continues to offer lonely support to Britain. Coincidentally, a few days after the ITLOS judgment, President Biden proclaimed that the rule of law was one of his country's most cherished democratic values, but not cherished enough, it seems, to extend to the Chagos Archipelago or the rights of the Chagosians. This was all a useful riposte to the Trump administration, a useful stick to beat China, but where's the beef? Let's wait until it's actually applied to Chagos. One act of lawlessness does not justify another. If, as the British and American governments now seek to do, they want to weaponize the rule of law, and to do so without ridicule, they'd better make damn sure that their own houses are in order first. Such acts of lawlessness have human consequences. They prevent Madame Élysée and others from returning to Chagos. Mr. Johnson and his government are in hock with the business, science and conservation bodies that I've mentioned. They're harnessed into serious wrongdoing. The 2009 US Embassy cable put the point with casual clarity. It noted that the environmental lobby is far more powerful than the advocates of the Chagosians. Let's be exactly clear what is happening here. The environment is being used to trump human rights. And such lawlessness has another dimension. International law treats the forcible deportation of human beings without lawful cause as an international crime. Some of you may have read my book East-West Street, telling how Professor Hirsch Lauterpacht persuaded Robert Jackson, the American prosecutor, to introduce the new concept of crimes against humanity into the Nuremberg Statute. The criminal acts listed in the statute at Article 6C included deportation, the forcible transfer of a group from one territory to another. This has since been followed up in the 1948 Universal Declaration on Human Rights and the 1949 Geneva Conventions, and more recently the Statute of the International Criminal Court, adopted in Rome in 1998, defines a crime against humanity to include the deportation or forcible transfer of population. Several leading lawyers have already expressed the view that the forcible removal of the entire population of the Chagos Archipelago was a crime against humanity. And they've also opined that the continuing refusal to allow them to return is a continuing crime against humanity. The ICJ and ITLOS have confirmed that Mauritius's desire to allow the Chagosians to return is well-founded in law. In November 2019, 3 judges at the International Criminal Court authorized the prosecutor to investigate the refusal of Myanmar to allow the Rohingya to return from camps in Bangladesh to their homes on the basis that this amounted to a crime against humanity, perpetrated, to be clear, not by Bangladesh, but by Myanmar. Human Rights Watch, the global NGO, is now looking into the international criminal law aspects of the continuing forcible removal of the Chagosian population. Watch this space. And so what is to be done? There is, in fact, a very simple solution, one that addresses the intertwined legal matters of the territorial integrity of Mauritius, the protection of the environment, safeguarding national security, and respecting the rights of the Chagosians. Britain, Mauritius, and the US have close and excellent relations, and India can play a vital role. So can other countries like Bangladesh and South Africa. Mauritius has sovereignty. That is now a legal given. The conservation of the environment of Chagos, including its pristine maritime spaces, can be protected by a proper and lawful conservation plan. Mauritius has made clear, successive governments, to the commitment to the conservation of the archipelago and the willingness to work with scientists who are already active, the British government and bodies like the Zoological Society and the Chagos Conservation Trust and the Bertarelli Foundation. The US can maintain its base on Diego Garcia. Mauritius has long made this clear. It has even offered a 99-year lease, providing a long-term security that is lacking under current arrangements, which is illegal and which will expire in 2036. And Mauritius has also made clear to the United Kingdom that it can have a role there if it wants to have one. And that reminds me of an unlikely connection between Lviv, the Ukrainian city that's at the heart of East-West Street, and Chagos. A few months ago, I received a letter from America. It said, "I'm a 79-year-old survivor of the Holocaust. I was born in Lviv in January 1942, and I came to the US in mid-1946, the writer explained. Only 3 members of his Lvov family survived the war. The rest perished under the command of my book, The Rat Lines, Otto Wächter. Thank you for your brilliant book, he wrote. It helped me better to understand who I am. We exchanged letters, and I learned that he was actually a retired US Navy pilot. So I thought, I'll ask, have you ever been to Diego Garcia? And he replied, actually, yes, I have, several times. We called it Boys Town. There wasn't much there, tents, a mess hall, etc. The big excitement was watching baby seagulls learn to fly. And he sent me a couple of photographs, including this one taken from the cockpit of his plane, which he asked me to credit to his friend, Lieutenant General Steve Newbury, which I happily now do. More letters followed. Was he aware of those who were removed? Dimly, he replied. We knew it had once been populated. Candidly, he continued, its political history didn't interest us back then. But now his interest was piqued, and he wanted justice to be done. I see the return of these islands, he wrote to me, to their original inhabitants as one of the very last stages of the decolonization of the British Empire. And then he added in a footnote, P.S. The Brits always were high-handed in dealing with colonial people. Just look at the American history for an example of that. Which brings us to the Chagossians, who were allowed to visit, as you can see from this photograph, a few years back in the most unfortunately named heritage visits. As a group, they comprise individuals with many hopes and aspirations. Many want to be able to return to the outer islands of Chagos, including Peros Baños, or to work at the US base on Diego Garcia, along with the other nationals who work there already today. The outer islands sustained human habitation for more than 2 centuries, and as KPMG says, they can do so still today. They are hundreds of miles from Diego Garcia. They pose no security threat whatsoever to Diego Garcia. Writing for the majority in one of the important Bancu cases before the Supreme Court, Lord Hoffman made clear that the contrary view, that somehow allowing the Chagossians to return to the outer islands would create a security threat or a threat of terrorism, was, and I quote, fanciful speculation, end of quote. There's a win-win-win outcome. Security, human rights, and an end to the forcible removals, the marine environment, and respect for sovereignty and territorial integrity can all be assured. The rule of law, treaties, UNCLOS are all promoted. Charges of hypocrisy and double standard can be cast to the wind. This is not a zero-sum game. It is time for Britain to lower the flag on what is its last colony in Africa, and it should do so honourably and soon. The alternative will be a continuing stain on Britain's reputation and authority. It will undermine Britain's ability to challenge the lawlessness of others. It will encourage the lawlessness of others. It will promote the view that Britain remains imbued with a colonial racist instinct. It will not assist Britain as it seeks to make its way in an increasingly complex and post-EU lonely world. Plus ça change, plus c'est la même chose. In the meantime, Madame Élysée waits patiently and with the greatest dignity imaginable. It has been an honour and a privilege to work for Mauritius and its people in this important case, and to be associated with the cause of the Chagossians. They will return to the outer islands of Mauritius's Chagos Archipelago. It is not a question of if, it is a question only of when. Thank you very much.
Thank you very much, Professor Sands. This lecture was, of course, incredibly informative. I was personally fascinated by the detailed historical facts behind the last decision of the UN General Assembly and the complex implications of that decision and where we are now. I was also deeply touched how you reminded us of the human tragedies, the touched lives, and the lost dignity that comes with colonization. And I was particularly touched by the testimony of Madame Élysée, if I recall well. So thank you very much. I would like now to open the floor to questions. I would like to invite you to write your questions on the piece of papers that we have left on your chair. And we have hostesses who will collect these questions. When you have a question ready, just please raise your hands. Yes, did you write your question? Can we have someone to pick up the question, Tanjali? Anyone else with questions? Yeah, one at the back. Okay. So I will take 3 questions at a time, and if that's okay, Professor Sands? Yeah, you've got a microphone. You just press to put it on green. Yeah, someone has come to help you. So the first question is, how plausible is it to ask, could the progress made so far have been made sooner? Could anything have been done at independence? Okay. How plausible is it to ask, could the progress made so far have been made sooner? And in particular, could anything have been done at independence? That's the first question. Second question, could you elaborate on the implication of being a so-called contract worker in Chagos versus being an indigenous population? From Rezat. And a third question from Marc 1, SC. In view of the deadlock on the Chagos issue, how to break the deadlock? Should we go to international mediation, and how to get there? We'll start with the 3 questions.
The first question, as I understood it, was could it have been done any sooner? It's very hard to see how it could have been done sooner. I mean, if one looks at the period of time, I've often asked myself the question of the appalling situation in which the Mauritian leadership found itself in 1965 when they went to Lancaster House. Imagine the situation they faced at that moment. And I have to say, having reflected long and hard on it, I can't see that Mauritian leadership could, in those circumstances, really have done anything else than what it did. It was faced with the possibility of maybe years more of waiting for independence. And I understand why that position was taken. And it's always easy with the benefit of hindsight to say, oh, I would have done things differently, or we could have done things differently. Things were as they were. Britain had been in colonial occupation for 150 years. And I think that community that was part of the moment of independence is entitled to have slack cut for it in relation to actions taken. Of course, once Mauritius became independent, it had to deal with its place in the world, and it took some time for things to get going until the early 1980s. And it faced then, some pretty powerful countries. So I don't really see how it could have come much quicker. I may be wrong about that, but I think the timing, and particularly the fortune, and I'm against Brexit, but the good fortune of Britain having voted against remaining in the EU, I think was pretty crucial in helping us over the edge. Ambassador Kunchal may have another view about that. On contract labourers or permanent population, I mean, there were about 2,000 people living there. Some were descendants of people who'd been there for decades or longer. Others had been brought in as contract labourers, but there's no question at all that there was a permanent population in the meaning of international law, and that they were descendants of people. I mean, Madame Élysée was born there, her father was born there. That's a permanent population, there's no question, under international law. So the argument that somehow, they were just, the British argument is not only offensive, it's just wrong as a matter of fact, and it's wrong as a matter of law. In terms of breaking the deadlock, I mean, it's in the end a political matter, but speaking only as a lawyer, you negotiate or you have mediation where there are two equally valid claims. There aren't in this case. The situation is crystal clear. The ICJ has ruled, ITLOS has ruled, the General Assembly has ruled. There is no debate about sovereignty. And the real question is what you do when you have a country that simply refuses to accept two international court rulings and the will of the international community as reflected in the General Assembly. Mauritius, I share with you this minor story. I gave a version of this lecture in London 2.5 weeks ago, and following the lecture from one of the attendees, who was a former British Cabinet Secretary and now in the House of Lords, wrote back and commended me on the lecture, agreed the direction that has to be taken. And then he said to me, why can't you just advise the Mauritians to do what we did in relation to the Falklands in 1982, which is just send its navy to Chagos with people on board and just reoccupy it. That would be lovely if it were possible, but for Mauritius's navy to take on, I think, the full might of the British and the Americans is obviously complicated. So that's not possible. I don't think that is yet possible. It may be in 50 years' time, given the way the British Navy is going, but I somehow doubt it. And so there are other means, and those means are political, diplomatic, social pressures, public shaming, Britain coming to realize that the price it is paying for what it has done is too high to sustain. And I get many communications now from Conservative members of Parliament in Britain saying this is simply not sustainable, we have to find a way out. And I think at some point there will be a crack, and when that crack happens, it will change pretty fast. But when exactly that happens, I don't know.
Thank you. We have another question from Ali Mansour. Realpolitik, as US will not give up Diego Garcia, a deal possible where the UK would accept Mauritian sovereignty over all islands except Diego Garcia, plus Mauritius accepts that Diego Garcia remains British. So your opinion on that possibility. Second question, given the still strong political, economic, trade ties between Mauritius and the UK, what is the actual likelihood of Chagos being fully returned to Mauritius? A bit of David versus Goliath. And a third question, what, in Professor Sand's opinion, are the next steps?
The question that's posed is, could we imagine a situation in which the UK retains sovereignty over Diego Garcia and Mauritius exercises sovereignty over the rest? I'm just a lawyer. My role is to help identify and implement legal strategies. That is essentially a political question. But I'd have to say, I'm hard put to imagine a single example in international practice where that has happened. I'm just trying to think off the top of my head where a country has just handed over part of its territory to another country. So if I were to be asked, is there a legal precedent for it? I would be bound to say I can't immediately think of one. I put my thinking cap on, but I don't think there is one that springs to mind in these circumstances. And then it becomes a political issue, and my own sense is Mauritius is in a very strong position now, and the position that it has adopted successive governments, you can have a lease, you can have a very long-term lease. It seems to me to be the right position. But that said, of course, it's a political matter for governments to do as they feel right. It would be an odd thing, having come this far and having obtained these rulings, to then reopen the matter. But as I say, that's beyond my expertise. What I can say is that Mauritius today has sovereignty over all of Chagos. What remains is only the exercise of that sovereignty. And that has got to be the starting point for any decision that is taken. The second question, can you repeat the second question? I made a note of it, but I can't read my own note.
Second question was, given the still strong political, economic, trade ties between Mauritius and the UK, is there any chance of a return?
The relationship between Mauritius and the United Kingdom is an excellent relationship, and as I understand it, politically the decision has been taken to ring-fence this issue from all other issues, and that's obviously a very important principle, and I know that Mauritius has stuck to that principle, and I understand Mauritius values its relationship with the UK, and the UK values its relationship with Mauritius. This is the last British colony in Africa. Why the United Kingdom is hanging on is very mysterious to me. It's probably nothing more than the feeling that it's the one thing they have to give to the Americans. As some of you may know, Britain has not only left the European Union, but it has just announced that it is in fact an Indo-Pacific country, which was a bit of a surprise to us living in London, that our new neighbours were Asian. But that is the position of the government, and in order to strengthen that position, it wants to have access to a base in the Indo-Pacific region, and it wants to have something to give to the Americans. And that, I suspect, is largely what this is about. It's not unconnected with the recent deal between Australia, the UK and the US on submarines, and it's at one with a government that is very hubristic. I mean, you're probably watching the United Kingdom from afar, but it's disrespect for the rule of law, it's contempt for judges and courts, it's contempt for laws and legal process, is something I have never witnessed before in a British government. You may be aware, for example, that this government has proposed literally shredding up the Northern Ireland Protocol of the Brexit Withdrawal Agreement, despite the fact that it is a binding treaty ratified by Parliament. So we're dealing with a British government that does not play by its usual standards, and I hope that in time normal business will be resumed. And at that point, the wiser voices in the Conservative Party and the position adopted by the Labour Party, the Liberal Democrats, the Scottish Nationalists will come to prevail, that the two sides will sit down and work out a sensible arrangement based on the law. And that is, I think, what ought to happen. That was also the next steps argument. In the meantime, before we actually get, or before the government of Mauritius gets the possibility to sit down, it will have to continue to do what it's done very efficiently, very diligently, rather effectively, which is to go to each specialised agency and tick them off one by one and say, that's it, buyout's gone, no more stamps, no more fishing, and there's about 20 more specialised agencies to go through, so that'll take a bit of time, and the British will lose votes, presumably in all of them, and eventually a British government will arrive. I hope it's not like South Africa. I hope it doesn't take 24 years to sort this out, as Namibia did. But the South African government, P.W. Botha, eventually said, yes, this has to come to an end. And there will be a British government that will say, yes, this has to come to an end, and it will come to an end. I'll stick my neck out and simply say that I think Mauritius just has to stick to its very diligent, very courageous, very principled stance and follow things through all the way to the end. and justice, I think, will be done over the longer term.
How can Mauritius challenge the recognition of British Indian Overseas Territory by non-governmental international organizations such as ISO? Today, anyone in the world doing a website requiring a drop-down list of countries will use the ISO 31666 International Standard Country Code. First question. And from Guillaume Huguenin, it is said that at the time of independence, financial compensation was paid to the Mauritian government. Is that a fact? Was there a mention for the compensation, and does that give a claim to the UK?
Sure. It's a really interesting question about what to do with hybrid type organizations like the ISO, which are not sort of only fully governmental and which don't have dispute settlement mechanisms. I think the starting point is the General Assembly resolution. And the General Assembly resolution directs all states, all governments, all intergovernmental organizations, national, regional, and that, to my mind, includes hybrid organizations, to implement General Assembly Resolution 73295. So what needs to happen, and I can assure you, minds are turned to this issue with various of the organizations, is how to implement 73295 in relation to bodies like the ISO or the domain name issue, which is not subject to an international treaty. That is obviously much trickier. I think one can envisage further measures possibly in the General Assembly which address the issue of those organizations that do not wish to take steps. And this goes in parallel to the question of the private organizations. I mean, one of the things that has been sublime in this experience is the sheer quality of the local team working in Port Louis, the diplomats, the civil servants, the legal advisors. And I've spent 35 years doing cases before international courts. I've worked with a lot of governments around the world. I can honestly say that the quality of the diplomatic, civil service, legal representation in Mauritius is second to none in the world. I'm talking about a lot of countries, north and south. But there are limits to what a small number of people can do, and plainly one of the issues that will have to come up is if you've got a private telecommunications company issuing contracts for telecommunications on part of the territory of Mauritius without a license, someone somewhere eventually is going to have to look at that. But it takes time and it takes resource and it takes energy, and those are the kinds of things that I suppose one does incrementally. But I think, again, there are mechanisms available in domestic law of Mauritius, in international proceedings at the UN General Assembly certainly, and maybe in due course further international proceedings, to address recalcitrant organizations that don't wish to look into this. Having spent a bit of time looking into the domain name thing, it is devilishly complicated. I can tell you, it's a sort of network of private companies that run this .io business, and it's going to take a bit of unpacking to work out where the center of gravity is and where you have to put your pressure. On the question of compensation, yes, compensation was paid on more than one occasion, originally in 65 and then again after 82, but the International Court of Justice in effect said that's neither here nor there. The crucial question was consent. And the court gave an absolutely definitive view on that. The Mauritian leadership in 1965 that attended the Lancaster House meeting was subject to duress. And so the consent that was said to have been given was vitiated and without any effect whatsoever. And the consequence of that means that the act of dismemberment is not only voidable, it is void ab initio. It never had any legal effect. The Biot construct has been illegal from day one. And the issue of compensation doesn't come into it because Resolution 1514, according to the court, is concerned only with the question of consent. Putting it another way, you can't buy consent. with a handful of pounds and shillings. That's what essentially the court is saying. And that position is crystal clear. And on policy grounds, that's a really important principle to establish, because it means that going forward, if other situations arise that are analogous or even slightly different, you can't avoid your legal responsibilities simply by the payment of compensation. This is very significant right now. I'll just close again with a way of saying that the world of international law is changing right now. Something very significant is changing. And one of the markers of that was the decision of the International Court in the Chagos case. But equally significantly, in my view, is the decision just a few weeks ago, or a few months ago, in the summer of this year, of the government of Germany to recognize that its treatment of the Herero community in Southwest Africa, when it was a German colony, was a crime of genocide. Why is that significant? As far as I know, and I know a little bit about genocide, this is the first time ever that a state responsible for such treatment has recognized that its acts constitute the crime of genocide, even though they occurred at a time before the concept of genocide existed in international law. So this is hugely significant because it opens the door to all sorts of other issues, whether it is mistreatment of human beings or repatriation of plundered artifacts that now populate certain museums in Western Europe and the United States, Canada and other places. The door has been opened. And even more significantly, Germany is paying to Namibia about €1 billion in compensation, but it is without prejudice to the legal rights of Namibia. And so what you've got is the slow creaking opening of a new international legal order. And it's difficult because it's slow, but I think it's also vastly exciting. And that is now a changing world that we occupy.
Thank you very much for your questions. Thank you, Professor Sands, for your elaborate answers. We're going to close the question session now, but I would like to invite His Excellency Ambassador Kunjul for some concluding remarks.
Thank you, Miriam. I think you will all agree that this has been a very exciting session. Professor Sands has been able to give a pretty comprehensive report on where we are with the whole issue of decolonization, which is basically the fundamental point on which we went to the International Court of Justice. Mind you, as you all know, we never took a case against UK on a bilateral basis. This was a case of incomplete decolonization that was sent to the ICJ by the General Assembly, which indeed is responsible for decolonization of countries. You will also agree that the questions that were put to Professor Sands were very interesting questions and certainly meant not only to provide ways out, but also to get clarity on some of the issues. I want to just perhaps take one or two of them, and that has to do with the issue of timing of the action. I always believe that there is a time for everything to be done, and when the time is not right, I always feel that we are not going to succeed. I think in this particular case, the timing was absolutely perfect. You will recall when I said that 2016 did not appear to me to be the right time. If we had proceeded with insisting on including the item on the agenda of the General Assembly, we would have faced tremendous opposition, which would have derailed the process. So in the same way, I believe that certain things happened which helped us, and that to me is important. On the issue of mediation also, I think Philippe has responded very appropriately. I believe that the determination of the ICJ is crystal clear. The judgment of ITLOS, which says that the claims by the UK of sovereignty over the Chagos Archipelago can be mere assertions. This is what ITLOS calls the assertions of UK. So we have got a very, very strong position with the determination of the ICJ and the ruling of ITLOS, and I don't think that we should be the one seeking mediation. As a matter of fact, from what we are hearing from colleagues at the FCO, the Foreign and Commonwealth Office, many of them, they say it openly, and this is what they say. They say that it feels like the ground under our feet is shifting. So, which means that they are in a rather delicate situation, but because of some political consideration and some other security considerations, they are not yet in a position to agree to implement the decision of the United Nations General Assembly or the ICJ advisory opinion. But this position of the UK, in my view, is not tenable. It is not going to be possible for them to hold on to that. Even those three countries which Philippe had mentioned, Hungary, Israel and Australia, with regard to Maldives, things have moved already because Maldives decided to be absent from the vote at the Universal Postal Union. It did not participate in that vote, which meant that it had shifted its position already from a full support to the UK. We believe that Australia will also change. In fact, within Australia, there appears to be a number of think tanks which are firm supporters of the rule of law and who eventually will insist on the government that they have to abide by the rule of law. UK's position is also getting weaker. Only yesterday, UK failed once again to elect a member to the International Civil Service at the level of the United Nations. That again shows that its position as a global power is beginning to wane. Mauritius and the UK have excellent relations. UK is a great partner. Of course, as a bigger power, sometimes they use the strong arms, sometimes they try to make certain threats. But I think the days of threats are gone. I don't think the world will tolerate threats anymore. And sooner or later, UK will have to come to some kind of an agreement. So I think this session hopefully has been interesting for you, has been educative for you, and I hope you go back from here not only knowing much more about where we stand, but also being able to speak to your friends, to your colleagues, and I am addressing myself especially to the foreign representatives who are here, that they can also talk to their own government and explain to them the position. I think it is through this system of dissemination of information, sensitization, that we will get more and more countries not only talking about it, but supporting our cause. So thank you very much once again for your presence and for being here. Thank you.
Thank you, Ambassador Kunjul. Before we close this event, I would like to convey my thanks to Ambassador Kunjul and Professor Philippe Sands for making this event possible. Thank you, Professor Sands, for sharing your invaluable knowledge, experience, and analysis of the Chagos Archipelago issue with our guests, a lecture that will stay with us for a long time. We hope that we can welcome you again soon, maybe when you will be yourself on your way to the Chagos Archipelago, alongside all the Chagosians who have been waiting to return. I would like now to invite you both to stand up. We have a small token of appreciation to give you. Before we leave, there are a few more words of thanks to be said. First of all, thank you very much to our guests here present today, but also online. Thank you for your thought-provoking questions and intervention this afternoon. I would like to thank the Prime Minister's Office for choosing us to host this event, and in particular, I would like to thank Ms. Martine Young-Kim-Fat, Minister Councillor, who has supported us all the way in the organization of this event. But of course, this event would have been nothing without a rock-solid team at Charles Telfair Centre and Charles Telfair Campus, and I would like to thank Suren Soulal and the head of IT and maintenance and his team. I would like to thank Kanya Santoki, our head of marketing, Tanjeli, Sanish, who have supported us and that allowed this event to be a success. I would also like to thank the team of 4 Rental Equipment Limited for their fantastic IT and sound support and allowing the live streaming this afternoon. Ladies and gentlemen, I would like to leave you with this quote by the political philosopher Frantz Fanon. For a colonized people, the most essential value, because the most concrete, is first and foremost the land which will bring them bread and above all, dignity. Thank you very much, good evening, and please keep safe.